to Victim's View, a show produced by the Solicitor General's Office. I'm Carmen Smith, the Solicitor General. The Solicitor General's Office prosecutes misdemeanor cases in state court. Cases involving juveniles are handled in juvenile court. The Office of the Child Attorney represents juveniles in deprivation cases. Today we're talking with Willie Lovett, Director of the Office of the Child Attorney. Thank you for joining us today.
Oh, thanks for having me.
Can you just generally tell us, what does the Office of the Child Attorney do?
Well, the Office of the Child Attorney represents children who the state has alleged have been abused or neglected. And we get approximately 1,500 to 2,000 children that come in the system every year who have alleged to be abused and neglected in Fulton County.
And Fulton County is the largest county. I would imagine that you do get a lot of cases, but when you say you handle these cases, are they all in juvenile court or are they in other courts in the system?
Well, 99% of the cases we handle are in juvenile court. Sometimes our clients also have matters in other courts, and our attorneys, because once we become the attorney for the child, we may go to other courts and help the courts understand their situation. So we have traveled up to like Gwinnett County to talk to some judges about criminal charges against one of our victims of abuse and neglect.
And you are the director of that office, correct?
I am the director.
And what's your role?
My role is basically to keep the office together, to essentially be the face of the office, and to make sure that the policy set by our Child Attorney Board, which is a board of citizens who have some knowledge of the abuse and neglect system in Georgia, make sure that the policies set for the office by that board are enacted.
And what kind of staff do you have to do this?
Well, I have 18 attorneys. I have a social worker plus, at any given time, 1 to 5 social work practicum students who are getting their licenses to be social workers. I also have 2 educational advocates, one who is an attorney and one who has a PhD in educational systems working for me. Many of our clients, because they're in the foster care system, their school records get lost. And when they move from county to county for their different placements in foster care, they may get held back in school because they don't have the records. And so much of what we do on our educational advocacy program is to make sure that those children are in their correct grades, that they graduate on time, or that they find an alternative to graduation, usually the GED.
You mentioned that they're in school. What ages are we talking about? Is there an age range or an age limit on which you represent your clients?
Yeah, our clients range from newborns up to age 18. Newborns. Yes, generally when a newborn comes into the system, the mother has tested positive for drugs. Giving birth, she fails the drug test, and so if the child shows that there's some drugs in their system, they're automatically brought in to the foster care because that mother has not demonstrated at that point in time that she can be responsible for a child.
And so from newborn up to what age?
To age 18.
To age 18.
Yeah. The goal of the system is to have the child obtain what we call permanency, which means that they go from the foster system into a family situation where they can stay until they're age 18. In some cases, a few cases, a child may reach age 18 without achieving permanency, and in those situations, we call that aging out of the system. There are some options available to the child, and as their attorneys, we try to get them to sign themselves back in. which gives them an extended stay under the foster care system, so that there are options available, but generally from age newborn to 18 is our client base.
So that must present some other challenges for you. I know you've mentioned the social workers. How do they come into play in this scenario?
Right. Well, the state office of the Department of Family and Children's Services, commonly known as DFACS, every case is assigned a caseworker who is generally a social worker. So our office interacts with the social worker to try to make sure that the permanency plan for that child is enacted. So we are the child's mouthpiece, the child's advocate in court to make sure that the case plan gets enacted so that child reaches permanency. In our own office, we have our own social work staff, and we use them sort of like in-house expert witnesses, so that when we're reviewing the plans that are submitted by the department, we can run that and talk through it with our social worker to make sure that that's the best option for that particular child.
And you mentioned the state. Is this a state office, a county office, a city office?
No, we're totally a county office. We're fully funded by Fulton County. The office was created as a result of a lawsuit called Kenny A. versus Purdue. And in that particular lawsuit, Fulton County was sued because at the time we utilized child advocate attorneys who worked for the juvenile court judges. We were sued by an operation out of New York called Children's Rights, and they alleged that by working for the judges and by having enormous caseloads, back then we had 4 child advocates, all with over 1,000 cases each, that the children who were supposed to be getting legal representation were not getting adequate legal representation. And Fulton County settled that lawsuit and entered into a federal consent decree, which created the Office of the Child Attorney. And after the office was created, we staffed it. We started out with 12 attorneys, and now we're up to 18 attorneys. We stayed in the consent decree for 4 years. We have exited the consent decree, which means that the office is operating at a great standard, that the children are receiving great representation, and now we're actually an independent department running on our own, no federal oversight, and we're doing our thing in juvenile court.
That's excellent. I would think that every county has one of these offices. Is that correct?
No. It's really interesting. Only Fulton and DeKalb have offices that are purely designed to represent children. DeKalb County was also sued in a lawsuit because they operated much like Fulton County and had child advocate attorneys working for judges, but none of the other counties in the state have this. It's very interesting that you mention this because there is a bill pending in the state legislature. It's called the Child Protection and Public Safety Act, and it's been close to being passed for the past couple of years. There are some funding issues involved, but in that bill, a version of our office would be required to be created statewide in every county.
So in other words, you sort of would serve as a model of how this particular office should be.
We would be. Our office and DeKalb County's office would be kind of the models for how offices, if the counties decided to set up child attorneys' offices, our offices would be models that they could follow.
And in your office, you also, as you said, you focus totally on representing the child victims, correct?
Totally.
Okay. And as far as the parents are concerned?
The parents actually have a right to counsel, and in Fulton County we have, the Public Defender's Office has a parents' attorney division. So indigent parents get their own counsel through our Public Defender's Office. If the parent is not indigent, they would hire their own counsel. But for many of our clients in the system, the parents are represented by the Parent Attorneys Division of the Public Defender's Office.
Do you also answer questions if the viewers had any questions they had about the system or just didn't know where to go? Could they call a certain number and reach someone in your office?
Sure. We field questions from the public frequently. The number is 404-612-4756. That is our main number. We generally cannot talk about the cases because they are confidential. And under state law, all the juvenile cases that we handle are confidential. The records are confidential. But in terms of giving advice and telling people where to look for certain services or certain answers to questions, we do that frequently.
And so when you say that it's confidential, how important is that when you're dealing with a young person?
Well, not state law is very strict that juvenile records are confidential. As you know, juveniles' criminal records are sealed and they can't be disclosed. And in a similar vein, in abuse and neglect cases, the records of the child and the record of that family's involvement in the system is sealed. So it's really important because in the juvenile court, the idea is that you're making people whole and not punishing people. So we don't want, and the system doesn't want, a family to have a record in juvenile court and have that be held against them as they're seeking to make their lives better. So it's a very, as a public policy piece, it's very important that these things remain confidential.
Well, we're going to take a quick break, but stay tuned because when we come back, we're going to learn more about the Office of the Child Attorney. Welcome back to Victim's View. I'm talking to Willie Lovett, Director of the Office of the Child Attorney. Mr. Lovett, could you kind of give us a walkthrough of how a typical deprivation case would be handled by your office?
Right. Well, Carmen, as you know, there's state-mandated reporter laws, so that many people who work in professional fields that come into contact with children, nurses, school teachers, people even now in daycare centers, if they see what they consider to be abuse or neglect, if they see welts or bruises on the child, they're mandated by state law to report it. And once that report is made, the that particular report is investigated by DFACS, and they have what they call a Child Protective Services division that investigates the complaint. If the investigation reveals questions that they can't answer, if they can't explain why a child's bone is broken, or if they can't explain why the child has a huge bruise on the side of their face, then the case is referred to juvenile court. DFACS brings a complaint to juvenile court, and the court then conducts what we call a probable cause hearing, much like what you have in the criminal sense, where you have probable cause to move the case forward. And at the probable cause hearing, the state puts on evidence to show that there's probable cause that abuse or neglect occurred.
And when you say the state, that's the district attorney's office at that
No. Actually, this is DFACS.
DFACS, okay.
Yeah, DFACS, as we talked earlier, the parents have attorneys, the children have attorneys, and DFACS actually has attorneys. They're called Special Assistant Attorney Generals, or SAGs.
SAGs.
Yeah, the short we call them SAGs, but they represent the department. And so every courtroom has a group of SAGs that represent the department, or as we call them, the state, in these complaints. And they bring the evidence forward, and the parent attorneys will try to rebut the evidence to argue that there's not probable cause for abuse or neglect. And the child attorney is generally there representing the child, but in that particular issue, unless it's a child that's old enough to explain that maybe the neglect or abuse that they're alleging did not occur, we generally sit and let the court decide whether or not there's probable cause to move the case forward. If our child, for instance, explains what occurred and it's consistent with what the parents say, we would probably end up on the side of the parent attorneys and argue that there is no abuse and neglect during the probable cause hearing. If, on the other hand, the child communicates to us that they've been getting beaten or abused, we would argue more so on the side of the state. So on any given day, our attorneys fit into the picture either at that phase, arguing with the on the same side as the parent attorney or on the same side as the state attorney. And then after the probable cause hearing, if probable cause is found, the case goes to what we call adjudication, which is a formal trial. That's where the state has to prove every element of their complaint.
And during this period of time, where is the child? Is the child still in the home, or?
Well, generally the child will be placed either with a safety resource or in a foster home if probable causes are found. So the child will be removed from the home if there is a concern about the child's safety. So the state will find and is required to find a place to house the child while this is going on. And sometimes, as you know, cases can get continued. So it could be, technically they're supposed to happen within 10 days, but sometimes it may take a while before the actual adjudication happens. So during that time, the child is in a safe place.
What would be an example of why it would take longer than 10 days?
Well, if for instance, there's evidence that still needs to be gathered, or there are expert reports that have not come in yet, the court will reconvene it and continue it.
Medical records, psychological records, that
Exactly, exactly. Because oftentimes, because you're at that normal level of trial proof, to go forward, you may need more than just the testimony. Now, some judges don't continue them, and if they don't, then the state has to go with what they have.
And then at that juncture, is the child present in court, or are you just there on behalf of the child?
No, we try to bring our children to all the hearings, unless they don't want to come.
Is that a challenge for you to explain to them what's going on in the process?
Actually, no. The attorneys in the office are very skilled at child interviews. We go to trainings, we go to continuing education, kind of CLEs about how to talk to and how to get information from, and how to create that sense of trust with the child so that, one, they know you're their lawyer, but they also kind of understand what's going on in court. So they can make informed decisions. Sometimes, for instance, a child may not want to come because something's going on in school, and we'll waive the presence of the child. Other times, the child wants to be there and wants to participate in the hearing. And in those times, we make the arrangements for the child to get there and to be present in court during their hearings.
And then you make arrangements for them to return to the foster home or wherever they're placed.
Correct. Now, DFACS, the state agency is responsible for transportation. So we would make the request to them to transport the child from wherever they are to be at the hearing.
And what's the role of the juvenile court judge at this point?
Well, the judge's role, the judge is hearing arguments from three different sides. So this is and the most important role in this is the judge has to decide what's in the best interest of the child. So that's the judge's role. Oftentimes we represent children in what we call a client-directed model. So to the extent that we can, we present the child's wishes to the court. So if the child says that they want to go back home into an abusive situation, and sometimes that is the case, then our job as that child's attorney is, okay, what kind of supports can be placed in this home to protect that child from any of that potential abuse, and that would be our argument to the court. Now, the judge doesn't have to accept that, and frequently the judge will not. But because we're the child's voice in this hearing, that's our role to do that.
When you say support can be placed in the home, what do you mean?
Well, the judge can order that certain services in terms of, like counseling. The judge can issue protective orders. For instance, if the abuse came from an outsider, like a boyfriend or a girlfriend who's living with the parent, the judge can order that that person have no contact with the child. So when we talk about support situations, those are the kinds of situations we're talking about.
And if the child, for whatever reason, does not want to go back to the home, I guess you would also...
We would argue that. And we frequently get that, where children want... There may be a reunification plan in place, which means that the goal of the proceeding is to bring the child and the family back together. And the child may want to remain in foster care longer.
And these are all decisions that the juvenile court judge would make?
Ultimately makes. Right.
Okay,
right. The judge is the ultimate determiner.
So walk us through the decisions that they make. Their option would be either to remove the child, correct?
Correct.
Or what could be the other options?
Well, it depends on what stage of the proceeding you're in.
The end, the last...
At the end, that's called permanency in the permanency hearing. Oh. So when you reach the end, let's say that there was a reunification plan and the parent failed the reunification plan, that the parent didn't do the steps listed in the plan to bring their children back. Then at that point, the judge could decide, well, you failed the reunification plan. Does the department have a motion? And generally, the department will move at that point to terminate the parental rights and place the child up for adoption.
Adoption?
Yes.
But the entire process is really whatever is in the best interest of the child, correct?
Always, always. That is the ultimate goal of the process, is what's in the best interest of the child.
Great.
And the secondary role is keeping families together.
Excellent. Well, I want to thank Willie Lovett for being here today. I'll be back with some final thoughts about the Office of the Child Attorney. Unfortunately, there are children who are deprived and neglected every day. Fulton County is fortunate to have the Office of the Child Attorney provide juveniles with legal representation. These attorneys advocate for emotional, educational, and medical needs of these children. I want to thank the Director of the Office of the Child Attorney, Willie Lovett, for joining us today. Thank you for watching Victim's View, and we'll see you next time.